Okay, hi everyone. So today we have a very beautiful and a professional lady with us, and that is Dr. Radhika. So, Dr. Radhika, we welcome you all on Yopedia.
Thank you, thank you. And this is a fabulous platform to discuss about the topics that are quite general as well as the specific. The today's topic, that is intellectual property rights, I think so this is going to be a budding topic for all the researchers who are starting their research career and also who are in the midterm or a long term in their careers.
So yes, it's going to be a very fruitful discussion. I have jotted the list of a long list of questions. Above, I think 50 questions are there, and I'll be telling you one by one, like what is patents all about, and if you're a budding engineer, researcher, and if you want to file a patent in future, do watch this video. It's going to be really helpful. Ma'am, if you permit me, can I start with the very first question?
Yes, please.
Okay. So, what is meant by IPR?
So IPR, as we say, we see that in universities, taglines, they say that we have to promote IPs. So what are IPs? These are the intellectual property rights, the rights which are granted for your intellect, for the creativity that your brain has generated. That's simply, that in a simple language we say it, an intellectual property right, a right over the intellect and the creativity that comes directly from your brain.
So please elaborate, like what are the different types of IPR?
So anything that is intangible asset that generates out of the intelligence of a person, they come up with a creative output, and there are different 7 domains under which intellectual property rights are granted, starting with the patents. These are the most common one and the most crucial in terms of giving an economic value. These are the monopolized rights that are provided to a person who invents something new that is novel, nobody's heard about him, and it has an industrial applicability. So that is patent. Likewise, we have other kinds of intellectual property rights. Let me start with the simple one with whom like we all can connect. It's the geographical indication. Like we all know, there are certain specific attributes our region has. Like I'm from Punjab, I know that Fulkari is very famous from here. So what is a Fulkari? Fulkari has got a geographical indication tag. So that is a specific creativity that originated from one particular region. That's why we call it geographical.
Yeah.
Likewise, there, like in southern, there is the silk saris, they have the GI tags. Likewise, India has number of GI tags that is credited to the geographical region, the climate there, the people there. Then there are other forms of intellectual property like trademarks. There are the specific rights that you get over your mark, and trademark becomes so important when we are running business. Like we all know that Coke as a trademark is so popular. Then starting with the Coke, the another form of intellectual property right that is associated with it is trade secret. We all are fan of Coke, but do we know what are the ingredients of Coke? So that is kept secret since ages. So you can protect your intellect, your creativity in a form of a secret also. That is known as a trade secret. Like for KFC, we don't know what is the ingredient inside that. That is a trade secret. Then there are other forms of IPR, like we get specific rights over the integrated circuit. Then we get rights over the design of a particular substance, like how the bottle is designed, how this laptop is designed. So we get IPs over them also. And there's another category that gets special rights for plant varieties. The seeds which are coming up, our farmers and our researchers, they have produced hybrid seeds. So they are also protected under IP.
Okay, so it was a good discussion. Right now, I want to know that are these IP rights territorial in nature?
They're absolutely territorial in nature. 100% they are valid in the region where you have applied. Like if I have applied for a trademark registration in India, it is valid only in India. But then there are certain international agreements and negotiations are happening in which we can file an international application, like for trademarks, for copyrights and everything. We can mention him. But generally, they are restricted to a region, they are territorial.
Okay, so let's come to the main point. Like, what is a patent actually? Many of the kids are not even aware about this term. So, please explain this term.
So, patent are the exclusive rights that we get on something that we have created out of an invention. Like I invented a pen. Like suppose there is a pen, I invented that. Then I can file a patent on that. Once I get that patent, I get an exclusive right that I can only produce this pen and I can only market this pen to the world.
Okay.
So that exclusivity that is provided, that right that is given to you over an invention is known as patent.
So is there any term of a patent, different term which is used in India?
So earlier there used to be different forms of patent that was provided in many other countries. We call it as utility model also. For small utility you get it, but generally the term that we use is patent only. And now internationally it's been 20 years term of protection that is provided to a patent
Okay.
since the time you have filed it with your national office.
So people generally know it with the term patent only, right?
Yes, yes.
Okay, right. So next one I want to ask you, like, which is that act in India which governs this patent system?
It's the Indian Patent Act that was first formulated in 1970.
Mhm.
Before that, we were following the Patent Act of British time because British has ruled us. So we were following the same act. It was in 1970 a full-fledged
Right.
Patent Act was introduced,
Mhm.
and since then there are many amendments that have been introduced to this Patent Act. The latest amendment was in 2005. Reading this patent act is itself a very informative process. There are number of sections and there are number of clauses that were added in this patent act in terms of how a patent should be used in the
Right.
country, what all comes under the patentable subject matter, what all we cannot get patented, like anything related to atomic energy, we just
Mhm.
cannot get it
Okay.
patented. Then there are certain patent rules which are also added that say whatever is written in the act, how you're going to implement, then we have a separate jurisdiction known as patent rules for that.
Okay. And is this like, does Indian Patent Act give protection worldwide?
No, so as we discussed right now,
Mhm.
that patents are territorial. So this Indian Patent Act is only for India. It doesn't give you protection to the other
The
countries. We will discuss subsequently how an international patent application can be
Okay,
made.
right. So tell the kids that what are the list of the things that can actually be patented?
Anything that comes out of your mind, any invention that you have made, anything that is new, that
Mhm.
is for the very first time you're introducing, anything that has some application, you're solving some problem of the society, it has some industrial applicability, that can be patented, and that should have an inventive set, something very new that no other person has thought of. So anything that comes into this is known as a patentable invention. With the Indian Patent Act that we discussed about the jurisdiction also, there are certain things that are mentioned in our Indian Patent Act that we cannot get patented. As I can see, there is one question also what we cannot get patented. There are certain technologies or invention related to atomic energy. We just simply cannot get them patented because they belong to the strategic sector and the security of the nation can be compromised with that. Then there are certain mixing of some substances
Mhm.
and producing something with the same effect. You cannot get that patented. Any algorithm that we develop, we cannot get that patented.
Okay.
Any kind of a mathematical models that cannot be patented. Any business strategy plan that you make that might be new, that might be novel,
Right.
but you cannot get that patented.
So what is the ultimate process or the criteria to get this patentability?
So simply there are three criteria that we call them as a patentability criteria.
Right.
One is it should be new and novel, absolutely new to the world. If that information is already available in the public domain in any form, whether you have done some kind of an interview, like in an interview, if I discuss about my idea and later on I go and file for a patent, I won't be able to get patent because that novelty criteria I have missed because that information is already available in the public. So that is very important. It should be brand new information. Second is that there should be some inventive step in that, some R&D carried out due to which there was a specific invention that has generated out.
Mhm.
And the third most important criteria is it should have some commercial utility.
Right.
We can see that market is there. It is going to help somebody in the market.
So as we already mentioned, like what are the things that cannot be patented, right?
Right.
So apart from it, any invention you missed it and you want to tell that which cannot be patented?
There are a couple of them, so we have a dedicated section. So I will request my readers to go through that section in Indian Patent Act. You can just simply type Indian Patent Act in Google, and that proper act will open, and the language is simple. You can go through the Patent Act itself. The section 3 and 4 is all about what cannot be patented.
Patented,
Any like surgical method, we
mhm.
cannot get it patented. We cannot get patent plants and animals.
Okay.
Only the modified microorganisms can be. So there are a number of other things also that are there in the section that says that this cannot be patented.
So when when an applicant can actually file a patent?
So today, if I have an idea, I know that that is going to show a commercial utility, I can file a patent. So there is a very good phenomena that Indian Patent Act has, that has a provisional specification. So today we are having a discussion.
Right.
We are sitting somewhere in the lab.
Right.
We got an idea. We saw their preliminary results are coming, and it's something very new, and it has some commercial utility. I can simply go to patent office. I can file a provisional application. So provisional application is only giving a glimpse of your application.
Right.
It's not you're showing the complete specification of your research or invention. So that will give me a time around 12 months to develop on that particular idea. So an inventor who is the first hand inventor who has got an idea, he can simply go and then file a patent. Or like suppose I'm sitting in a university, I can ask my university on my behalf to go and file a patent.
Okay.
And that term is known as an assignee. That I
Assignee.
have assigned that task to my university to go and file a patent, because I'm working in a university, so automatically that asset, it belongs to the university.
Right. So can an invention be patented even after we have shown it in the public exhibition or something?
So, like I mentioned, the novelty is a very crucial attribute. But there are certain clauses, there are certain cases in which we have seen that they have showcased in some conference. Like in conference I went, I started speaking about my research. That was recorded somewhere.
Right.
But I was not aware that is being recorded. There are certain circumstances under which I can claim that I was not aware, or this was only for the research purpose, or it was only for the closed room discussion.
Okay.
Then, in certain cases to cases, circumstances have happened that they were able to take it as a patent application.
So it depends on the situation.
It depends on the situation, but we should be extremely careful. And especially to my young researchers, I want to say that if you have some brilliant idea, some brilliant invention, don't go and disclose it to anyone. Keep it the secret, because the secret will lead to your patent application.
Okay, so what about the patent office? How they keep the information secret, or do they tell to anyone?
So, like we make an application, we provide whatever is required in an application, then we submit it to our patent offices. In India, we have 4 patent offices. Like I am in Chandigarh, so in my jurisdiction, I will go and apply to New Delhi office.
Right.
Similarly, they are in southern part, in eastern part. Like we have different patent offices. So for first 18 months, they get an application. They keep it top secret. That is between in the office only.
Right.
So that information doesn't go out. It's only after 18 months there is a process known as patent publication, where we open it to the public to take the feedback from them. That is the only time it gets publicized, but till that time it's kept secret with them.
So do we need to visit the patent office to get the transaction of any business related to patent application?
So earlier we used to go with like full bundle of papers, go to these offices and submit our application. But today we are in digital India world. And in digital India, one of the clause that has been introduced by patent offices, electronically file your application. And I must also congratulate the government effort, and the fees that they have come for the electronic filing is quite cheap as compared to the one if I go to the office in person. So that's kind of an incentivization for all of us to sit in your office and file an electronic
digital
application.
India. We are making digital India. Okay. So next is like if I suppose I get an idea, right? So I want to get it patented, but it has already been patented. How will I get the list? Like what are actually granted patents and where the list is provided?
So first of all, if I'm sitting in a lab and I have some idea, I want to get it patented. The first thing that we have to do, the term that we use is prior art search.
Okay.
The term is that whatever is happening in that particular area, you have to do a literature survey for that.
Right.
And for that, there are certain international platforms, there are certain internet platforms, like in Google Patents. So we all know Google is one of the best searching platform. So they have developed a separate platform for searching the patents. So that is known as Google Patents. There are certain other paid versions also available. If we talk about the Indian scenario, the Indian Patent Office every week it releases a journal in which all the information related to how many patents are filed, how many of them
Okay.
are granted,
Right.
it comes and that is online available. You
Right.
can simply go, you can download that journal and see the information.
Okay. So who amongst all can get the patent?
Any one of us, like if you have an idea, you can go and get patent. We need not to have any particular degree for that.
Okay.
If I am an inventor, I'm eligible to get a patent.
So anyone without any age bar or something,
No,
all
they
can
have
get the
no age
patent.
bar.
Right. So can a patent be granted on the basis of provisional specification?
Yes, so that's what, like if you have an idea, you know that it's going to stuck in a
Mhm.
commercial utility in the market. I can file a provisional application, but you will not get the patent till the time you have filed a complete specification. So to answer this question, it's no, not based on provisional application you will not get patent. Provisional application is only, it's the way to give you time, just to fix yourself that yes, you are going to get a patent, you have got the priority date. That
Right.
is very important in patent. It's actually a race in which
Mhm.
who comes first and who goes and files the patent first is going to win that race. Like today we both are discussing
Right.
it,
Hmm.
but then tomorrow we have some conflict, and then you think that you should go for a patent,
Right.
like separate
Mhm,
application.
mhm.
I will go with the separate
Right.
application. Out of us, like who's the first one to
To
reach
reach
to
over
the
there.
patent office, that person will win,
Okay.
irrespective of the fact who has developed the invention. So provisional application will give you that advantage that I had an idea, I went and I provisionally applied for that. But till the time I will not give all the details, I will not get patent.
So whosoever has an idea first, go and run
Go
and file
and
a
have a
patent.
provisional
Okay.
specification.
So let's make it very simple. How can I apply for a patent?
So you just open a Indian Patent Office site. Just
Okay.
type in a Google IPO.
Okay.
You will get there, and then you will get a detailed summary of how the process of patent application
Mhm.
is. And then there are certain forms that we have to see, starting with form number 1, in which you make a request that I want to go for a patent application.
Right.
Then form number 2, then which you will request that I am going for a provisional application or a complete application. So similarly, it's a very simple process. You simply go to an IPO website and you will find bundle of information that is floating there.
Okay. And how can one obtain the digital signature?
So yeah, like if we are talking about having an electronic process of
Right.
filing an
Mhm.
application, how you will authenticate that you are the one.
Right.
So that's where a digital signature play a very important role. So what patent office has done, they have certain authorized persons that are being available online only, from where you can submit your signature. They will authorize that signature and then you can use them as your digital signature. So IPO has that authorized agents through which you can get your digital signatures.
So all our Indians are like different languages are there in different states or cities, right? So is there any particular language bar or something in the patent office for the application
So
filing?
there is no language barrier as such.
Right.
The two common languages that we can use is Hindi and English. And English is the major, like
Yeah,
being an
exactly.
international language.
Mhm.
So English is the preferred one, and in Hindi also we have seen the patent application.
So
not
both
in any
English
other-
and Hindi
Yeah,
can be
both
helpful, right?
languages, right.
So is there any jurisdiction also like for filing this patent and all?
Jurisdiction is, yes, there is. We have to follow the Patent Act rules
Okay.
and whatever is written in the law itself.
Right.
And then the guidelines that are given by the patent offices, we have to adhere to them.
So can you just list me all type of different applications?
So there are, starting with provisional application, where you just give a glimpse of your idea
Right.
and the invention.
Hmm.
Then you have a complete specification. In complete specification, we have to, as the name says,
Mhm.
complete. You have to give complete information. Who is the inventor? Who is the assignee?
Okay.
What all fields under which your patent application
Right.
falls in? What there are certain numbers that we give to your kind of a research that is being carried out. Then you
Mhm.
have to give some drawings. You have to describe your research. Then you have to give the prior art also for that. You have to present the case for your how it is commercially utilized. Then you have to give summary. So the complete specification has number of things that we have to write. Then there are certain applications known as conventional application. Like if we are going for an international application also. So in many countries we are going to apply. The first application that we will consider, because date is very important here,
Okay.
that is known as a conventional application. So these are the options and types of applications.
And what is the importance of filing? Like, is it necessary to file an provisional application?
It's not necessary, but
Mhm.
it is just to buy a time. You file a provisional application. The necessary is the complete specification and the complete application that you have to file. Only if that complete application gets thoroughly reviewed by the patent examiner,
Right.
then only you will get a patent.
So when is the application actually published? Like,
It is from the 18 months from the time you have applied for an application.
okay.
So that's an 18 months window is given in which it is being thoroughly reviewed by the patent examiner.
Mhm.
And then after 18 months, it's open to the public domain. And how it is open, I mentioned about the journal that
Right,
is
yeah.
being released by
Mhm,
the patent
mhm.
office. So every Friday, number of new patent applications are being published there.
So 18 months period is there, right?
Right, 18 months is
It
the
can exceed
minimum.
also, or it can
It cannot exceed. It is the 18 months, but before 18 months also you
can
can
get
have
it.
a specific request made to the office that I'm in hurry to get a patent. Like
Right.
it's a very valuable
Mhm,
thing and I
mhm.
have to get it. Then you can request them like before 18 months also you can get it.
So is there any provision in the Patents Act for early publication?
Yes, early publication. Like if I think so, this is a very strategically important research, and we have to quickly get the patent.
Right.
Then to speeden up the process, I can request. I have to pay an extra fee for that,
Mhm.
and then I can get it published.
Okay, great.